Namaste. Telugu Pradala Manasakhi Sakshi. I am Swarna. Welcome to Sakshi TV English show with Attorney Prashanthi Reddy from the Law Office of Prashanthi Reddy LLP. Please note that Sakshi TV now has 3 English shows every week: Tuesday at 3 p.m. EST with Attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with Attorney Ms. Prashanthi Reddy, and on Friday 6 p.m. EST with Kanu Lee. Please tune to ask your questions. If you have any queries regarding immigration, please feel free to call. Our attorneys would like to answer your questions. If you are immigration attorney and would like to join our special shows, please email us at usca@sakshi.com or call us at 866-725-7441. Before beginning the show, please note down the information provided in the show is not legal advice, it's for general information purposes. Activity or its agents are not responsible for this information. If you need a special advice, please contact attorney directly. Today, we are going to talk about alternative H1-B. For that, we are here with our attorney, Ms. Prashanthi Reddy. Without any further delay, let's start our show by welcoming Ms. Reddy. Hi, Ms. Reddy. How are you? How is your day?
I'm good. Thanks, Varna. How are you?
I'm good. Thank you and welcome to the show.
Thank you.
Thank you. So, can you please provide your information about the practice areas and your experience?
Yeah, so I am located in Midtown Manhattan. I practice immigration law and I have been an immigration attorney for 20 plus years now. Our offices, as I said, are in New York City, close to Penn Station. And yeah, we practice business immigration and family immigration as well.
Okay. So, viewers, if you have any questions and would like to reach out to directly, you can call her at 212-354-1010 extension 107, or you can email her at prashanthi@reddy.sq.com. So, before any delay, let's start talking about H1B alternatives. What are the available visa options, Ms. Reddy?
So many of the viewers might be available that the visa numbers H1, we can't file any new H1s anymore for this year. As you all know, that in March the visa lottery opened up and it was available for 20 days and then the registration period closed, and then the results also have come out for the registration, and the time period to apply for actual H1Bs, that is also over as of June 30th. So we're done with the H1s, and there are a lot of people who ask me, what now? We still have employees, or I have a job and I need to come in. What do I do? How do I come into the country? Is there any other option other than the H1B? So the idea today is to provide an overview of the alternative visa options for a H1B, so that you don't have to wait until October 2022 to come to the US or to file a change of status if you have a job. So that's the whole idea of the show today, trying to provide some alternatives. Briefly, there are many, but we will do like a bird's eye view on what alternatives are available for the H1B.
Ms. Prashanthi, before we talk more about it, we have a caller. Someone from DC is waiting.
Hello. Hello.
Hi, Suman. How are you?
Doing well, ma'am. Thank you so much for taking my call and chance to express my question. The question here is, my husband divorced me after getting green card through me. He came to this country with a H4 visa, and during his H1 tenure, he did not work that much, but he maintained the marital status until I got green card. And after 1 year of my green card approval, and he got as a dependent, then he divorced me. How does the immigration look into it as a fraud? Is there anything I can do about it? Can you please?
Well, it depends on whether. So was it a fraud? So if you are not married, if it was not a bona fide marriage, then it's considered to be fraud. If he did it only for getting the green card, in which case then both of you are involved in a fraud. So, some people get, pay money, and, we know the scandals that go on, and say that they're married, but they're actually not married. But in your situation, it doesn't seem to be like that. It seems like a bona fide marriage. But the only thing is your husband was opportunistic and waited until he got the green card and then gave you a divorce. So that's not really a fraudulent marriage, because you were living in the same household, you were living, as husband. So if
Yeah,
that is
in my
the case, then it's
situation,
not fraudulent.
he left the home 2 years before, and but he maintained the address and marital status until the green card, and he has an affair with. I mean, now it is coming to surface, but apparently he has an affair with his college mate, and now he's living with her. And kind of after getting green card, right out within 1 month, he changed the address, and there was no way I could figure out where he was. I was trying to pursue with him over the phone, and in-laws doesn't help. I'm trying to pursue, but apparently there are indications and where he's involved in an extramarital affair, and he's
So
divorcing me
that
based on,
itself, unfortunately, that itself doesn't qualify as fraud. And since the marriage was still valid and you did not file for a divorce and he did not file for a divorce and you still had a valid marriage, as long as the marriage is a bona fide marriage, which means that the marriage did not happen for the sake of getting the green card. So the instance where it happens for getting the green card is when, two people, strangers, get together and they don't know each other, and the intent was only to get the green card, and then they, defraud the immigration. That is a situation of fraud. Your situation most took advantage of the situation, but it's not really fraud in the sense that the marriage, was done, I guess, for legitimate reasons, and you were, husband and wife, then didn't get along, I guess, and so he left, but you didn't take any action of filing for a divorce or anything like that. So the entire process happened, and now he has his green card, so there's not much you can do.
Yes. Okay. Understand that. Okay. So nothing can be done. Okay.
No, because you can't really prove fraud here, because then you will also be involved in the fraud. So I don't think it's actually fraud in the sense that immigration looks at it. Two people getting together and getting married for the sake of getting the green card. That's not the case, right? When it first happened, it was a legitimate marriage. You got married and everything was so. Things didn't work out that well after, but then that doesn't necessarily mean that there was fraud. That's the issue here.
Thank you, ma'am. Understand. Yeah.
Good luck. Good luck with your situation.
So, Ms. Reddy, before we talk about more details about visa alternatives, we have Mr. Prashant from New Jersey, another caller. Hello, Mr. Prashant. Hello, Mr. Prashant.
Hi. Hi, ma'am. Actually, I have a question regarding my wife. So my wife and kid both are in India, and my kid is a U.S. citizen. My wife has a valid H4 visa stamp on her passport. And recently this year, my wife also got a H1-B picked up and petition is approved. So my question for you is, my wife is not getting any visa appointment for H1-B stamping. Can she travel to USA on H4 visa stamp and apply for H4 EAD to start work here? I have my I-140 approved in US.
Yes, she definitely can. She can come since she already has a H4. She can come on the H4, get an EAD. EAD, will not be immediate. It could take 4, 5, 6 months, 8 months to get the EAD. So as long as she's willing to wait, she can come on a H4, apply immediately for EAD and start working once she gets the EAD. But coming back to your wife's H1, if it was a cap subject H1, then unfortunately, if she doesn't work on that H1, then next year she'll have to file under the cap again. She will not be cap exempt. She'll only be cap exempt, once she starts working on the H1. So then you will lose that, opportunity, and you'll have to go back to the lottery again. That's the only thing to keep in mind.
So what is the earliest we have to get the H1-B stamp? Means if the appointments are not available till next year, still the petition will remain valid?
Yes, it will remain. So in the interim, if she still has the same job from the same petitioner, she can work on H4EAD, and then once she gets the appointment for an interview, she can move to a H1.
Okay. And one more question. So if she travel on the H4 here, is there a way the employer can file H4 to H1B change of status?
No, because she is subject to the cap, and only that H1 which was filed previously, only that can be used. But perhaps an amendment can be filed from H1 consular processing to a change of status. So you're not really filing a new H1, you're filing an amendment simply to change status. You can try doing that. Sometimes they accept it, sometimes they don't.
Okay. Okay. Thank you.
You're welcome.
Ms. Reddy, we have another caller, Srinivas Rao from Virginia. Hello.
Hi, ma'am. This is Srivatsu. Can you hear me?
Yeah, we can hear you. Srinivas.
Perfect. So I got a question about the H1B cap this year. My employer filed a petition this year, and then my case has been through. It was approved on the case status, but then during the during the encashment of the checks, that's when we've received a notice of intent to revoke, stating that the financials have not been through, like they've not been processed. So there was an issue from the bank, who actually marked the checks as void. But then,
Right. So what is your question? Did we lose him?
Yeah, I think we lost him already. So we have another caller, Prakash from Dallas.
Hi, good afternoon.
Hi.
Thank you for taking my call. My question is, my immediate relative is on US on B1, B2 visa, and I am a US citizen. Can I petition them while they are in United States?
Yes, you can. You have to wait for 90 days to show that there's no intent problem, because if they came on a visitor's visa, the USCIS, they should not have had an intent to adjust when they were coming on a visitor's visa. So usually USCIS says that if you wait for 90 days, then that intent, they no longer think of it. There's no longer any intent issue. So wait for 90 days and then file for adjustment or get married or whatever it is. Whatever the immediate relative. Who is the immediate relative?
My mom and dad.
Oh, your mom and dad. Okay, so then let them. They can come on a. If they're here on a visitor's visa, wait for 90 days and then apply for them.
Oh, okay. So when I do the concurrent filing, can I do the EAD and I-131 advance?
Yeah, so you have to do the I-130, 485, I-765, I-131 all together.
Oh, okay. Okay, so 90 days from the time of the entry they entered.
Yes, correct. And if you have any questions, you can reach me offline. I'll be happy to, go into the details with you.
Thank you so much.
You're welcome.
Thank you.
So viewers, if you have any questions and would like to reach out to Ms. Reddy directly, you can call her at 212-354-1010, extension is 107, or you can email her at prashanthi@reddy.com. So, Ms. Prashanthi, our topic is like H1B alternatives. So what are the available visa options?
So I was, Swarna, thinking that we should answer that question that person kind of half asked, but I'm hoping he'll call back so we can, if he doesn't, then we'll try and answer his question. Hopefully he'll be listening. And in the meantime, I guess we will get into our topic and talk about, the H1B alternatives. Because he almost finished his question, I think, but he didn't get a chance to listen to the answer. So the available visa options, as I said, there are many. And the first one would be obviously to wait for the um, second lottery, because for those who don't know, usually, last year they had two lotteries because of the sudden economic downturn because of COVID. A lot of people registered but didn't actually file, and there was a significant amount of duplicate filings as well. As a result of which, even though the registration was full, not all the people who registered were able to actually file, because people thought that they had a job opportunity but lost it afterwards. Because remember, the registration happened last year in March, just when COVID hit, and then they actually had to file after that. So they had to file by June ending, and by the time they had that opportunity to file, they lost the job because COVID then was in full swing. The same kind of thing is happening even this year. A lot of people have registered, but there are a lot of duplicate registrations. Applicants, beneficiaries, or the employees file with two or three different employers because they to increase their chances of getting picked in the lottery. Because their chances are so slim. So they have to do everything possible to increase their chances, and this is what they do. And it's allowed by USCIS because one employer cannot file two applications for the same employee, but an employee can file two applications for different employers. So, so that's the story. So as a result of which, a lot of duplicates were filed. So a second chance lottery will most probably open up in July or August. And then, we don't know what the pick percentage will be, but definitely a good idea to wait and see if you get picked in that second lottery. And if you do get picked, then of course, then you don't have to think of any of the other, alternatives for the cap.
Miss Reddy, sorry to interrupt. We have Srivatsa from Virginia. We have our caller who called us earlier.
Oh, okay.
Hello, ma'am.
Hello, Mrs.
I'm sorry my call is dropped before.
No problem. Go ahead. Why don't you ask your question again? Yeah.
Sure. So my H1B application has been processed in this year's cap. I was approved, and then I received a notice of intent to revoke from USCIS because the financial payments didn't go through. I mean, the checks that we sent out, they were voided by the bank. So, we're trying to sort them out by, sending the replacement checks even before getting the notice of intent to revoke. So now, based, for the follow-up on the NOIR, we are trying to see what would be the best way or any odds of, getting the approval retained with us.
It really depends on the officer. Usually, if so it was approved, and then after it got approved, you got a notice of intent to revoke. Is that correct?
Correct.
After approval.
I've applied through the premium processing. I've got the approval. I got the I-797A.
So which check got both the checks got voided, premium as well as the filing fee check, or which check got voided?
Yes, I think all of them.
All of them. Okay. I was hoping it's just premium, in which case then they cannot actually cancel the H1. But if it's the actual filing fee that got voided, usually there's no tolerance for that. If the employer didn't have funds and he sent a bad check, usually they don't tolerate it. So they will not
Okay.
approve it. But if it is a case where the bank messed up, then maybe there'll be some tolerance to it, but it's important to show that it was not your fault or your employer's fault, and this was something that was beyond, your beyond anything that you could do. And so
Okay.
it's important to submit that documentation from the bank, letter from the bank saying that it was their mistake, emails, whatever you can get from the bank stating that it was voided in error, if there was an
Yeah,
error on the
and
bank side, that is.
yeah, I'm sorry. One more thing to add was, even before my case was approved, we knew that the checks were voided by the bank because they have foreseen a fraud, and they have notified us, like my employer. But then, we've immediately responded to it and sent out the replacement checks to USCIS and opened an email case with them. So now, would that be one of the things that we strongly rely upon while sending the follow-up to them?
The fact of the matter is that they'll think you sent bad checks. Whether you tried to correct it before they sent the NOIR or after, really doesn't matter, because the fact of the matter stands that as of the date of filing, you sent bad checks. So you have to prove that those checks were not bad, that there was some fraud in your employer's bank, and they were forced to void all the checks that were issued. So I'm sure the bank, if that is the case, will give a letter stating that this is what happened and we had to close the account and void the checks, and as a result of which these checks got voided. I'm sure the bank manager will give a letter.
Yes, we are definitely working with the bank to get it, and I got a couple more weeks to send the follow-up. I think that answers my question. Thank you.
You're welcome.
So, Prashanthi, we have our next caller, Padma from Dallas. Hi, Ms. Padma.
Padma, thanks for taking my call. I have a question on filing H1-B extension from my current employer, and at the same time, H1-B transfer from my client in parallel. In detail, I work for a company A to a client on H1-B. Now my client is offering full-time position and started H1-B transfer, and my current H1-B valid till this year end. And my current employer also filing an H1-B extension for same client project. Can these two things go in parallel, or will it clash and cause any issues to my case? This is my question.
So what you should do is file the one that you want more, you should file that under premium processing. And the one that you're filing as a backup, you should file under regular processing. And then once your premium processing case gets approved, you should employer has to be willing to withdraw the other case. That, having said that, if you don't withdraw one of the cases, then whatever case was filed last, that becomes your status. So if you file it's not parallel, even the days they'll look at. They'll even look at which day you filed. So it can't be parallel, right? Same day, same time, it can't be. So there will be some difference in days. One will file today, one will file tomorrow. So whatever you file last, that is going to be a status if both the H1s are get approved. Because you don't have any control over the employer withdrawing the petition, I would suggest that you file the extension first and then you file the transfer in premium processing, so that the transfer petition will be your go-to petition, if that makes sense.
Okay, ma'am. Thank you.
You're welcome.
Prashanthi, we have our next caller, Ashwin from Reddy. Hello?
Hi. Hi, this is Ashwin. I have two questions regarding, one is related to the H1 and another one is the 485. I downgraded EB2 to EB3 in October. As of now, I didn't get a EAD or advanced payroll or I-140 approved. So I went for a couple of times for the I-140 premium, but they're denied for the premium process.
Right.
So my question is, if I want to leave the country and come back on H1 visa stamping in Hyderabad, so what will happen? My I-1 for 485, only I-131 will be denied, means abandoned, or entire green card process will be abandoned? That is my first question. And the second
So let
question
me
is,
answer your first question. So if you file advance parole and you don't go for biometrics, then the case will get denied. But if you go for biometrics and everything is done, if you leave the country and go for your visa, your 485 is intact. Nothing happens to your 485. So you can come back on a H1 visa, but if you don't get the visa, then it's a different story. Then the advance parole has to get approved and mailed to you. Then you'll have to come back on the advance parole.
So you mentioned a biometric means EAD biometric or 485 biometric? Because when I spoke with
not
Emma,
EAD or 485, advance parole biometric.
yeah,
So they only take one biometric
in,
anyway. So.
Okay. So Emma, when I do the chart with the Emma, they mentioned the biometrics are waived for the EAD. They mentioned, but I don't know whether it is.
Yeah, the advance parole also requires biometrics, but they use the same biometrics that they take. It makes no sense for them to take it 3 times, right? So they only take it once and they use it for whatever they need to use it for.
So I need to wait for the biometric.
EAD as well as advance parole. Advance parole also requires them to look at biometrics.
So again, 485 also biometric will be there again?
No, it's the same biometrics that they use.
Okay. So I need to wait for the biometric. Okay. Thanks for that one. And second question is, if I go to the India on my emergency purpose, so I have my recently, means that is on July 1st, my visa has expired. It was stamped on my passport, but it was expired, and I am on extension right now, approved. So how do I get the emergency visas and as well as the Dropbox facility visas?
Well, there's no emergency here. Simply because it's expired, that is not an emergency. And why do you even need? I mean, why go for a visa now? What is the rush? Unless you have to go to India for some purpose.
Yeah,
there's no need
purpose,
to. Yeah. So what is the emergency? Why do you need to go to India?
Yeah, family emergency.
So depending on what the emergency is, you can ask for the advance parole to be expedited.
Okay.
Instead of going for a visa, that makes no sense. Ask instead for the advance parole to be expedited and get the advance parole approval and then travel if possible.
Okay, my father is not doing good, so he's in a critical condition, so that's what I want to visit India.
Try for your advance parole expedite. That's a good reason for expediting advance parole. And obviously you filed last October, it's been a year. I think the reason they're not processing your advance parole is because the I-140 is not approved. So they're holding on to that. So try for, when you're sending I-140 premium processing the next time, inform them about the urgency, number 1.
Okay.
And remember, you have to keep sending the premium processing back. Because first time you request it, they will not accept. Second time, depending on how quickly or how much time you gave them, they may not accept. Usually you have to wait for a month or so because they have to get the file. So depending on the timing. Yeah, but how much time did you give in between?
30 days.
Yeah, may not have been sufficient time to get the DOL file. So my suggestion is do that, send the premium processing back again, inform them of the emergency, do a service request or an expedited request online for your advance parole and then see what happens.
Okay, I'll do that. Thank you, ma'am. Thank you very much.
You're welcome.
Thank you. Bye.
Bye.
Prashanthi, we have our next caller, Suresh from Charlotte. Hello.
Hello, ma'am. Good afternoon. I'm Suresh from Charlotte. I have a question for you, ma'am. I'm with employer A, ma'am. So I booked H4 stamping for my wife. She's expected to go to Indian consulate on August 5th. But recently I got an offer from employer B, and they are processing my H1-B through USCIS. And I'm expecting a receipt number in couple of days. So should I ask my wife to hold on for a couple of more days, or she good enough to go with employer A? Can you please suggest him?
Are you still working for employer A, or no, you're not working?
I'm still working with employer A. I haven't resigned it. But the problem is the employer B might be filing a H1-B transfer case, H1-B. I may get a receipt when she's going to when she's going for a stamping at that point of time.
So are you going to start working for employer B when you get the receipt?
No, ma'am.
So you're okay. Let her go with employer A, because just the receipt is not an approval, right?
Yeah.
So you are working for employer A and you have not yet moved to employer B. If they ask, she can obviously produce the receipt. But if she loses the opportunity at the consulate, then I don't know when she's going to get her next appointment. She's very lucky to get an appointment in the first place.
Yeah, ma'am. But my worry is, ma'am, like when she's going with the consulate, is there any chance, like they said that your husband is already applying for employer B? Will that be any issue for her? Like I have an approved petition with employer A.
Yeah, but you can always say that you have not decided yet whether you're joining or not.
Okay.
You will decide upon once you get the approval. You will make that decision. Right now, you're continuing to work for employer A. You can always say that, right? And there is the validity period is there. Because if you cancel the appointment, then I mean it's maybe makes sense to cancel in normal circumstances, but in the circumstances nowadays where you very difficult to get a visa appointment, I would rather you hold off on your transfer than she lose her visa appointment. Especially since it's only August. Why can't you hold off on your petition then?
I mean, the thing is, ma'am, it's already went to USCIS. I cannot pull back the petition. It's already been with USCIS. I'm just waiting for the receipt to get it from USCIS.
Right. You should have held back, especially since the interview date is so close.
So what should I do, ma'am? Should I go ahead with the H4 stamping? Will that be any issue if she go with her employer?
I think she should try. She should definitely try. Even if there's an issue, then there's an issue. But there is no point in not going or postponing, because if you postpone, do you know what the interview dates are? She may not get it. I'm surprised she even has it now.
Okay, got it, ma'am.
Look at the next available appointments and then make your decision.
Okay, man. Is it technically is it valid, ma'am? Suppose in
and
case
plus, isn't there a travel ban? I mean, how is she going to come into the country if there's a travel ban unless you have US citizenship?
She is having. I mean, I'm having a US kid, ma'am.
You are what?
We are having a US kid.
You have a US citizen child?
Yeah.
Kid, you said. Okay. Yeah, so then she's eligible. Then my suggestion is look at available dates and then you make your decision.
Okay. In case if I don't get any nearest date, we'll go with this August 5th date, ma'am.
Yeah, worst case scenario, they'll deny it.
Yeah. Thank you very much, ma'am. Thanks a lot.
Okay. All right. You're welcome.
So we have Mohan from North Carolina. Hi, Mr. Mohan, please.
Hello, can you hear me?
Yes, we can. Mohan, go ahead.
Ma'am, I have a question. With H4 EAD, how many jobs you can do same time, simultaneously?
As many jobs as you want to do. As many jobs as you want to do.
I mean, I already working somewhere and then I'm getting another job. So I'm just thinking whether I can take it.
Take it. As long as you have enough time in the day to do 2 jobs, take it.
Okay. Thank you.
You're welcome.
So, Miss Reddy, would you like to continue about alternative visa options?
Yeah, sure. So, as I was saying, since the cap has already been reached, so March 1st, or March of next year is the earliest time that we can refile in case you have not been picked in the cap. So it's important to look at some alternatives to the cap. So one is if you're working for an employer who's cap exempt. So a number of employers may qualify to be cap exempt and are allowed to file for a H1-B petition at any time without having to wait for the cap. A cap exempt employer is an institution of higher education related or affiliated to a higher education institution, a non-profit entity. So basically, it's a non-profit entity that is related to an institution of higher education or just an institution of higher education. So like if you are working for a university, then you could be exempt from the cap. If you're working for a hospital, which is a teaching hospital that has an affiliation with a university, then you could be exempt. A non-profit research organization, like not just any research organization, but a non-profit government research organization or a government research organization. So all these come under the category of cap exempt organizations. And for a lot of you IT people out there, you might think that because you're working for consulting companies, so these consulting companies don't fall under any of these categories usually. But you have to remember, a lot of you are working for clients, end clients, who are hospitals, who are government organizations, they might be research organizations, they might be universities. So if you're working for any of those organizations as an end client also, even then you qualify for a cap exempt. So if you're working for an IT company, try to get placed at one of these organizations so you can file your H1 and you don't have to worry about being cap subject. Because I know a lot of students especially who file once, file twice, file 3 times, and they still don't get picked in the cap. And then they're, they don't know what to do at that point. They're desperate. So this is definitely one way, to find the right client and get that project so that you can then file for a cap exempt. So that's quite important. And maybe a lot of people don't think of it. And then the other ways, and of course, you contact us and we'll evaluate, whether the client is exempt H1B employer or not. And, we can definitely help you out there. The other is...
Ms. Reddy, we have another caller, Kumar from Virginia. Hello, Mr. Kumar.
Hi, yeah.
Hi. Please go ahead.
Hi, actually, I got married to a U.S. citizen. It is like 2018 October. I got the EAD last year, 2019 end, and it got expired 2020 December. So August 2020, I applied for the EAD renewal. But still, I did not get anything from them because of this COVID. And also, they had gave the 180-day extension that is also expired. So, what are the options at this time?
So you're still married, right? And you got married in the US, so you filed a 485, correct?
Right. Yeah, we had an interview, and it is also like after the interview happened just recently in the June.
Oh, okay.
And it is going through review, and that is also not. I didn't get response from that. Because maybe they'll take time. But the EAD renewal, that is also pending. So
Yeah, I think your main issue is the EAD renewal. The green card will take the time that it has to take. And since all marriage-based cases have to be interviewed, there might be a backlog at that field office where you had to be interviewed. But now that the interview is done, that's good news, because unless there are issues with your case, like it's a Stokes hearing or something like that, where they don't believe that you're married, or there's some issues. Remember, for all marriage-based case, there is a presumption of fraud, meaning they presume that it's a fraudulent case, and you have to prove to them that it's not. That's the burden of proof in a marriage-based case. So it's a very high burden of proof. But anyway, so if everything went well with your interview, you should expect to get most probably get the green card before you get the EAD.
Okay.
But if
Because
that
the
doesn't happen, and if
EAD
you
got
are
expired, even the 180D got expired, and somebody told me to call the USCIS, and I called them, and they even noted they gave some case number. But after that, there is no
so you
response.
have to, if it is outside of the processing time, which most probably it is, you have to ask for, that's one of the reasons to ask for an expedite request. Or do a service request saying that it is, you don't even have to do an expedite request because it is beyond the processing time. You just have to do a service request, which looks like you did because you got that number. And they say usually we'll respond back in 30 to 60 days.
If I contact you directly, can you just help me on this?
If you got what? I'm sorry.
No, I mean directly, I can connect with you later on.
So I'm be happy to talk to you, but just remember, being an attorney doesn't give me a magic wand and some special privilege to talk to someone and get your case approved. It doesn't work like that. If it did, then attorneys would be millionaires. So it doesn't work like that.
And all those stuff. Because when I look
We can
into
definitely talk
documentation, they are
offline
saying,
if you call, but I can't promise you. I don't want to promise you that I can do something and expedite your case. We have to go through the process. And there is a certain process for expedite requests. If you fall under one of those processes, then you can call Emma, or online you can request that expedite, and we can talk about what the criteria is to expedite, because there was a memo recently on who qualifies for an expedite request and who doesn't.
Ms. Prashanthi, we have our next caller, Chanikya from Portland. Hi, Mr. Chanikya, please.
Good evening.
Hi.
Yeah, I have a quick question. So the thing is, I am on CPT right now. So I came here to US to do my masters, and in my first masters, my H1-B did not get picked up. So I am doing my second masters right now. And luckily this year I got my H1-B picked up, and it's in the process. And I have got my wife, and she wants to study. So is it better for her to apply for F1 right here, or is it better to apply from India? We are trying to go to India by end of this year. So do we have any complications here? I just want your opinion on this.
So my suggestion is, if she wants to study, she doesn't have to be on an F1. She can study on a H4 as well. So the only disadvantage of studying on a H4 is you don't get the benefits of F1 status, which is CPT, OPT, all that. But you get, if you're on H4, you have H4 EAD. If you have an I-140 approved, so maybe you don't need that benefit. So just to make you aware that you don't have to be on an F1 to study, you can be on H4 as well. And that makes it much more easier, because I'm sure you must have filed for a H4 for her, right? Along with your H1?
I don't know. Can we file simultaneously during my H1 process for the H4?
Yes, you have to. You have to. Otherwise, she will fall out of status.
Okay.
Because if you change to a H1, she cannot be on an F2 anymore. She'll be out of status. So you have to do it simultaneously, or at least before your H1 gets approved. So please talk to your employer or attorney and make sure that they have filed that I-539 petition.
Okay, thank you
If you don't know about it, most probably they haven't filed, because the I-539 petition has to be signed by your wife.
Okay, I'm sorry, I was a little stressed up these days. So I will definitely find out that. Thank you for that.
Yeah.
And the main intent for her to study is to do the job, So if she.
So do you have an I-140 approved or no?
It's in the process. GC, they just started processing 6 months ago. It's in the initial.
So you should. So then you should be in the I-140 stage very soon. If your perm was filed 6 months ago, it should get approved in a month or two, and you should be able to file an I-140 premium processing. So you're better off she files for H4EAD instead of going the student route.
Okay. But at that time, if something happens to my H1 status, again, she will be also put into jeopardize, or So we just wanted to have two different visas.
That's correct. So you can file a change of status form H4 form. Well, now she's filing for H4, but once she gets the H4, from H4 to F1.
Okay. And she's currently on F2. She can even try
I know,
to
but
do,
she will not be on F2. She will not be on F2 from October 1st.
Okay. But she can file for a change of status right here in the US for F1?
Yes.
Is it okay?
Yes, she can. Yes, she can.
There won't be any major complications? That is the question.
I mean, with immigration, there's always, you cannot say that there will be no complications, but there shouldn't be if you file the petition properly. Don't file it yourself, get help, and do a change of status from either F2 to F1 or H4 to F1, depending on, what her status is at that time.
Okay, so if at all something happens from F2 to H1, F2 to F1, she will be having the dependency visa, right?
You can't have two visas at the same time. No, you have to decide which one you want.
No, I will apply from F2 to F1, and if something goes wrong, like during the application or if the USCIS rejects, she has a
no, she will not. I just told you. Her F2, she will not be in F2 status anymore once you get your H1. So if the denial happens, depending on when the denial happens, if it happens after you get your H1, she's out of luck because she'll be out of status by that time. So you have to file the H4 no matter what.
All right, got it. Thank you so much. You made it very clear.
You're welcome.
Ms. Prashanthi, we have our next caller, Suresh from Chicago. Hi, Mr. Suresh.
Hi, ma'am. Good evening. This is Suresh. So my question is regarding the F1 visa. My relative got the visa, and she's traveling to US. And there was one clause mentioned in the CBP that they are supposed to produce the NIE document. Is this something mandatory for the students traveling from India to US to produce the NIE document?
If they are, no, automatically, USCIS has made it very clear that they automatically qualify for NIE exception. They don't have to prove it for students.
Oh, so what I read in the CB portal is they have to reach out to the consulate where they attended the interview, and they have to write an email to them that you're traveling on so and so date. Then they will approve, and that document has to be shown at the port of entry. So I'm just curious,
So that process usually happens for those who need to show proof of NIE. And students, they have said very clearly that they don't have to show proof that they're eligible for NIE because they automatically qualify. But if so, I don't see why CBP will require an NIE document when USCIS, as per their rules, USCIS has said that they automatically qualify for NIE. But if they're requesting it, then you should get it from the consulate, whatever they're requesting. There's no point in arguing with CBP. But generally, CBP is not required, is not supposed to ask for any NIE documentation for students. For in other situations, yes, that is the procedure as you mentioned.
Okay. And on the stamping, they clearly mentioned that NIE under all PPS on novel coronavirus. So I don't know what does that statement mean, ma'am. So
that means that he's been approved for national interest exemption. That's an NIE. So he's already approved, and the visa was approved under NIE exception. because the person
So
is
they
a
clearly
student.
written on the visa stamp, they clearly written that
Yes,
NIE under all
correct. So they have
PPS
already
on
been
novel
approved under that,
coronavirus.
under NIE, right?
Okay. Yeah, because we sent an email, but still we did not get any response from them. But they're planning to travel on this weekend, so just curious to know whether it is must or not. So, but thank you, ma'am. Thank you very much for the word.
Welcome. Hopefully they won't give him a hard time.
Ms. Prashanthi, we have Vishwam from Texas. Our next.
Hello.
Hello.
Hello. Yes, ma'am. I'm calling you from Houston, Texas. I have a question related to green card processing. My priority date is September of 2013, but I am no longer working with that company. I moved to a different company, and this company has filed my perm March 17th of this year. So I was wondering what are the dates that they are currently processing, the perm dates? And the second question, whether I should
Yeah, it'll take about 6 to 8 months for them to process any perm case, and if there is an audit, it could take longer.
And my priority date was EB2 with previous employer. Should I file my I-140 in EB3 if it gets processed by August? That was a question, whether it will be processed by August or September of this year. It was filed in March.
We can't say. As I said, 6 to 8 months, so you count. March, April, May, June, July, August, September. By September or October, it will be processed.
Okay, and if it is processed
you
by
can
September,
decide that once the labor gets approved, depending on when it is approved and depending on the availability of the visa number, you can decide at that point whether you want to process it as EB2 or EB3.
Okay.
You don't have to make that decision now.
Okay, all right, thank you.
You're welcome.
We have our next caller, Kumar from North Carolina. Hi, Mr. Kumar. Please go ahead.
Hi. Thanks for my call. I have two questions actually. This is regarding my wife's EAD and H1-B. So first, I'd like to question the H1-B. So she is currently on H4 as a dependent of mine, but she got picked up on her H1 back in 2015. It was picked up from an Indian IT company, but it was never stamped. But she traveled on my dependent visa on H4 later in that year. So we just like to know, is there a way we can go for her H1 based upon that old pick on H1B?
So she's not cap exempt because USCIS is following the strict interpretation of the regulation, and they're saying that unless the person actually worked on the H1, they're not cap exempt. You might get lucky and you might get an officer who chooses to interpret the law in a different way, but most probably this will be the result, because they will say that she's not cap exempt.
Okay, so that H1 is, no longer being useful for us. We have to go for fresh H1 submission.
And the other issue is it's 2015, so if it's more than 6 years, that's an issue by itself. Even if she was on a H1, even if she worked on a H1, if it's more than 6 years since that happened, she is automatically subject to the cap again.
Okay. Thanks, ma'am, for answering that question. And my second question is about her H4 EAD. So her current EAD is going to expire on this current year, on December, and we are yet to file our extension. So keeping in mind that now the H4 EAD card going to take a lot of time to process, what will happen if we don't get her physical EAD card by the time it's going to expire? But if we get the approval notice, the C26 form, so will she be able to work?
Yeah, so USCIS has made that clarification, right? For because of COVID and the delay in production of the card, I-9s can be updated using just the I-797 approval. They don't have to wait for the actual card. So if the I-9 can be updated using that document, then I mean it follows that she can then work just with the I-797 approval.
Okay. So in that case, if employer asks for any evidence, like which document we should be furnished to them?
I-797 approval.
797 approval. Okay, ma'am. Thank you very much for taking my call and answering this question.
You're welcome.
Please, we have our next caller, Sudhakar from UP. Hello. Hello.
Hello.
Hi, Mr. Sudhakar. Please go ahead with your question.
Hi, thank you. Hi, ma'am. Thanks for taking my call. I have two questions. One is a generic question, like, my priority date is March 2015. Do you think that this October flush, the new financial new year comes, right? So, do you think my filing date will be coming, or do I have to wait? Another question is we have applied my H4 EAD for my wife in Jan 2021 to Vermont facility. When do you think that, when this will be getting processed? Because still the case was received. And one more thing is I have my H1 until Jan 2023. So I just want to know about these two questions.
So the first question is with reference to what? Can you remind me again? I'm getting old. I can't remember anymore.
My priority date is March 25th, 2015.
Okay. Yes. Whether the priority date is likely to get current or not? No, that's $1 million question. But I wish anyone could answer that.
About the filing date.
Yes. So you're asking me if your priority date will become current or not in September or October, correct?
Yeah. At least for filing for EAD, right? Not at final action date.
I know that. Even that, I'm only talking about that. No one is talking about final action date, because that's the next step. That's the next step.
Mm-hmm.
So we are expecting the filing action, the dates for filing to reach 2015, as per what Charlie Oppenheimer said. So he's given us some indication, and he's not sure about whether it'll reach 2016. But he did say in one of his, he has a YouTube channel called Charlie Speaks. So this information is available for everyone. You can go and check it out for the June visa bulletin. But he did indicate that it's likely that the dates for filing would reach 2015, but who knows, right? We can't say that for sure. And my guess is as good as yours. You have to wait until September to see. But yeah, if you look at his interview, he says that it's likely. Most probably it is.
Mine is EB3 category.
Right. I know.
Okay. And other question is regarding my H.
I can't hear you.
Oh, I think we lost. Okay. Thank you so much, Prashanthi, for clarifying all the questions. Viewers, before we wind up, if you have any questions and would like to reach out Prashanthi directly, you can reach her at 212-354-1010. Extension is 107, or you can send an email to prashanthi@reddysq.com. This is Swarna signing off. You're watching Telugu Prajala Manasakshi Sakshi TV.